debut senior judges be part of the bench. So I think the best way to resolve it was to constitute a full court, if you agree. And there are also requests in, I think, three CMAs for full court. So that is the reason why the full court has, all the judges have convened.
Frankly speaking, let me be very clear. Why did I file this petition?
No. We will come to your petition.
We are with you, sir. The full court should be there.
Achha, so, since there are CMA number 4207 has been filed by Pakistan Bar Council, who represents Pakistan Bar Council? So they had sought full court, and there are two more CMAs, CMA 3166 and 3199. They had also sought full court. So these applications have become, in a way, allowed. Okay? So now we proceed to hear your contentions. The rest of you can take a seat. Khawaja Sahab will first address, and then the others can address.
I'll hand it over to Mr. Imtiaz Siddiqui, sir, because he's, to be very honest, sir, at the time of the, when this was first heard by 8 judges, Mr. Imtiaz Siddiqui led the arguments. He's fully prepared, but I would like to say a few words.
Let's forget the past. Today is the first date of hearing.
I'll say a few words, and then I'll leave the floor to Mr. Imtiaz Siddiqui. I want to make it one thing very clear. When this Supreme Court Practice and Procedure Act came into force, or became in the form of a bill and later became an act, I read clauses 1 and 2 thereof. Your lords have this act in front of you.
I think one of the petitioners has filed it. It's CMA 5104. I don't know who is 5104. It's attached with it. Ji, please read it. Argue as you please.
By the end of your lordship,
which is the petition that you?
I will be starting from 6, sir, because 6 is the one when the orders have been passed. But may I also say?
No, you started with the Practice and Procedure Act. You wanted to read it.
I'll read it. But before I do that, there is an order dated 2nd of May.
Ajay Sahab,
let's forget about the past.
Because we are not, don't do this.
Okay, so I'll say, let's bury the past.
Don't bury it. It's part. You can't bury the past.
So, all right. For the time being,
argue as if you are arguing for the first
time.
Thank you.
But I do say here.
I may ask a question. Khawaja Sahab, idhar dekhiye. You have endorsed the sitting of the full court, which is fine. But I'm just wondering what will happen to Section 5 in the event if the law is upheld. There is a right of appeal that is provided under this law. In that case, then how do you visualize that right being exercised?
I was going to come back. I'm very thankful to leadership, because if the full court is going to hear it, then I have no right of appeal.
But in the event, since we are hearing the vagaries of this law, what will happen to this right if a full court is now going to proceed with the matter?
In fact, when I go through the law, there are so many things.
वो अपनी जगह है ना जी. Let's just assume बहस हो जाएगी. Section 5 को फिर क्या होगा? Will Section 5 not be exercised by one party?
But it says that an appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution.
Khawaja Sahab, if I may interject, you please proceed as you want to. Let's read the Act together. Whatever you want to comment about the Act, and please also address the query that has been addressed to you in your own manner as you wish. So let's start with the Act at least.
I would like to answer that when I'm going through this, because this is a...
So let's start reading the Act. You want to read the Act or you don't want to read the Act?
I will read the Act now. I'll start with Section 1. But first of all, let me say this one. I would just state this thing that by the end of your honest tenure, if I'm still alive, I would have completed 50 years of practice
Faez
in this
Saab,
honorable court.
can you please read? No,
Yeah.
let's not do that.
Let me say,
This is public time.
when I saw this act,
Let's read it.
Yeah.
When you saw it, we're not interested.
well, see the section 2 thereof.
Please read the whole act.
I read it. Whereas Article 191, I'm reading the preamble. 191 of the Constitution provides that subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the Supreme Court. Now, at present, there are the 1980 rules which govern the procedure here in the Supreme Court. Before that, there were the 1956 rules. The 1980 rules were on account of a judgment which came in 1979.
Faez Saab, please focus.
Okay, I'm focusing myself.
We know the 1980 rules.
Background.
No, please don't. We
okay,
don't.
sure.
We are. The country expects 57,000 cases to be decided. We would love to hear you, but let's focus on your petition. Now you have started reading. You started giving the history of 1980 rules. We know that. If you'll ask a question, please answer that. But proceed with your arguments.
I have said about this 1980 rules for the simple reason that if I read now section 2, it
Please
says,
continue. Don't jump to section
all
2.
right, and whereas Article 10A is of the Constitution, mandated right to fair trial and due process. Article 4 of the Constitution guarantees treatment in accordance with law. Article 25 of the Constitution prohibits discriminatory treatment, and right of appeal is a universal fundamental principle of jurisprudence, and Islam guarantees right of appeal. Therefore, pursuant of Article 175(2), read with Article 191 of the Constitution, this law is being enacted. The court will see that there is no mention of item 55 of the because that is the basic what can the parliament do? Parliament is not omnipotent. It has to go according to certain constitutional limitations. That principle of old principle that the parliament is supreme means that they are omnipotent, led by Dicey and influenced by Blackstone and Co.
Faez Saab,
So we all agree that
no.
Parliament has limitations.
Faez Saab, this law doesn't say that. Don't insert words which are not written there. Law doesn't say Parliament is omnipotent. Just restrict yourself to the act which you have challenged.
When I say this thing, that this very preamble does not mention.
It's
that they-
noted. Read it
Okay,
on.
Okay. And whereas it is expedient to make a law providing for certain practice and procedures of the Supreme Court. It is hereby enacted as follows. This act shall be called the Supreme Court Practice and Procedures Act 2023, and it shall come into force at once. Constitution of benches, that the crucial question which arose. Every cause, appeal, or matter before the Supreme Court shall be heard and disposed of by a bench constituted by the committee comprising the Chief Justice of Pakistan and two next most senior judges in order of seniority. Now, one of the 1980 rules, Order 11, read in this manner. Because if you have to correlate, it may be important to do that.
पहले अगर इस एक्ट को पढ़ लें हम ताकि हम सबको पता लग जाए कि इसमें क्या है
If your
क्या
lordship,
नहीं.
Sir, which rule were you referring to?
if you want to continue like this, we'll go ahead. Because my viewpoint is this, that this frame of these rules under Article 191 is the prerogative of the Supreme Court, sitting as the full court. When they framed the 1980 rules, the entire court sat together and in their wisdom, together they framed the rules. This abdication or this intrusion by the Parliament into the affairs of the Supreme Court prompted me to come forward and file this petition. Because I feel that every institution must remain within its own domain.
Khwaja Sahab, I'm here on this side.
It's right here.
I'm here on this side. If you could kindly formulate your exact legal proposition. What you are suggesting is that you do not have any objection to the untrammeled, unaccountable powers in one office. Is that your question?
My contention is this.
Are you supporting what has happened in the past?
I am supporting what happened in 1980, and I'm
So
supporting.
what is your legal proposition?
My legal proposition is this: that this power of forming the benches, etc., is the domain of the Supreme Court itself.
If this is your proposition.
I think you should read the law first, Khwaja
this
Sahab,
is-
and then formulate
let us-
the points.
let us first formulate-
Act पढ़ लीजिए, उसके बाद में
फिर एक-एक को
It is only
Then
2 pages act, then it is only.
Let me follow the Chief Justice.
Khwaja Sahab,
Let me read the law,
Khwaja
and then
Sahab,
we make my submissions.
if I may make your job easier, undoubtedly, it's sometimes very difficult and disconcerting if questions.
I know it's very difficult to get the answer questions.
Zara sun lijiye, Hazur. If you are receiving a lot of questions from different sides, you don't even know who is asking the questions. If one of your associates jots the questions down, please don't respond to it. We let you argue it as you want to. Let me just finish. You read the act. You just point out, either you say this entire act is ultra vires, a constitution, that's one contention. If there are certain particular portions of the act which you think are ultra vires, a constitution, please, as you're arguing, point that, formulate the contention and move ahead. You don't need to respond to every query immediately. It will make your life very difficult because you won't even know where the question is coming from. One of your associates can take. When you're done with your arguments, you can absorb the questions and respond. We will give you time to respond to the queries. ठीक है? तो आप please continue with the act.
Just can you take down the points and so that you can answer them. Second part of this section 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure, including the holding meetings and constitution of benches, provided that till such time the procedure is determined under this subsection, the meeting of the committee for the purposes of subsection 1 shall be convened by the Chief Justice or other 2 members of the committee as the case may be. The decisions of the committee shall be by majority. Now, this is what the Parliament has enacted. And the provision which they have used is Article 191. At this stage, I would simply say this thing, that when myself and Imtiaz will be answering your question and formulating, we would certainly refer to item 55 of the Federal Legislative List, which spells out whether the Parliament can make enactments relating to Supreme Court. If I may read 55 at this stage, it may be.
Argue as you want.
Well, all right. I'm just saying that your lordship should note item 55 of the Federal Legislative List.
Let's read it together. You wanted to read it. Let's read it.
We'll read it together.
Khwaja Sahab, I think before going, I'm here, left side, your right side. Before going to this entry, if you want, you may read Article 191 of the Constitution.
191?
What is said?
191 also.
Who made
In fact, I can start with Article 70, go on to 142, and then read 191 and go up to 55. Article 70 gives the power of legislation, and it is to the effect legislative procedure. And what it says is, a bill with respect to any matter in the federal legislative list may originate. I will skip that. I'll go straight on to subclause 4 of Article 70. In this article and the succeeding provisions of the Constitution, federal legislative list means the federal legislative list in the 4th schedule, sir. Then there is Article 141. Subject to the Constitution, Majlis and Shura Parliament may make laws, including the laws having extraterritorial operation for the whole or any part of Pakistan, and the Provincial Assembly may make laws for the province or any part thereof. 142. Subject to the Constitution, Majlis and Shura shall have exclusive powers to make laws with respect to any matter in the federal legislative list. Then I take your lordship to 191, which is to the effect subject to the Constitution. Again, subject to the Constitution and law. It is the Supreme Court. The Supreme Court may make rules regulating the practice and procedure of the court. The crucial words here are that the power has been given to the Supreme Court to regulate its practice and procedure.
These powers are under the Constitution, your right side. These powers are under the Constitution and the law.
Constitution and the law. I'll say also, I'll come to that also. Because when I reach 55, then it will be clearer.
Faez, if I may request my learned brother, I know it's very disconcerting, so many judges asking questions. So we will let you argue in your own way, and we will ask you questions. You don't respond, you just note it. And because then I know your chain of thought will...
Point is noted.
Chain of thought we don't want to break.
Constitution and law. Point is noted. Constitution and law. Point is noted of my lord that what will be my proposition, and also what Justice Mansoor Ali Shah has said, that how will I go and make my propositions, and to say how this law is not obtainable. But may I read 55 register?
Please do.
Because your lord may ask questions on that. 55 of the federal legislative list. It says jurisdiction and powers of all courts can be subject to the power of the Parliament under 142 and 74.
Faez, just read it as is. Don't interpret it. Then you can interpret it.
Okay, I'll go along with it. Jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list, and to such extent as is expressly authorized by or under the Constitution.
(2023) के खिलाफ दरखास्तों की समाअत जारी. चीफ
84(3) is not the only part.
Sahab, you can later answer my question. So what you are saying is that the expression subject to the Constitution and law, this becomes redundant? That is the question. That is what you are interpreting it.
I'll answer that. We'll answer that. We noted, we'll answer this thing. But my basic question, why I came before your office, is that the functions which are there with the Supreme Court, there should not have been there with the Parliament. Because that institution that has its own, today they say that how you are going to have the benches. Tomorrow they will say that such and such bench will have this case, such and such bench will have that case.
No.
They can say that also.
Please, let's not go into what they may or may not do.
Why I'm saying is this, that if I give them unbridled power, then anything that happens.
Khwaja Sahab, it pertains to your attack on a particular piece of legislation.
But I will
Please
say this thing.
no. What Parliament decides to do future, you can bring another petition, we can look at it then. Restrict yourself to your case. Please proceed.
I will say this thing then, Maharaj, that this clause 2 is beyond the powers of the Parliament. Three, and when I'm arguing, Maharaj, my associate will explain that 184.3 is not the only thing which is regulated by the Supreme Court rules. If your Lordship would have the 1980 Supreme Court rules in front of you, there are the different types of jurisdiction which are available to you.
Shall we finish with the Act quickly?
Okay, I'll finish with the Act, Maharaj. Exercise of original jurisdiction of the Supreme Court. Any matter invoking exercise of original jurisdiction under Clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by 1 of Part 2 of the Constitution is involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court of Pakistan, which may also include the members of the committee for adjudication of the matter. I will simply say on this thing that this is...
Sir, on your right side, but not as much right as previously.
Yes, Maharaj.
Over here. Question, so your associates can note this. This power that Section 3 purports to confer on the committee with regard to examine the question and therefore act as a gateway perhaps, is this a power or is this a judicial power or is this an administrative/statutory power? Because 183 is ultimately a judicial power. Because then it seems to me that the latter part of this section says it shall constitute a bench. That seems to imply that the power exercised by the committee is not a judicial power, but an administrative power. So can Parliament whittle down? Is the question, please note.
Yes, it's judicial, and in fact, that will be exactly my proposition.
Please, here is Lordship.
Can the Parliament whittle down the judicial power under 184.3 by providing that this committee will act as a gateway and block out in exercise of administrative power anything that the committee feels? 3 judges, not the whole of the Supreme Court, but 3 judges. Senior most respectable judges, but in the end, just 3 judges. Block out any case that they, in exercise of administrative power, they will deprive the Supreme Court from exercising judicial power. So you kindly note the question and you address it at an...
And I will go even further than that.
And also a supplementary question connected to this. Earlier, the justice solely had this power. So there was a likelihood that the outcome of the cases could also have been influenced by the constitution of the bench. So that eroded the independence of judiciary. If this argument is accepted, then the earlier traditional model would be acceptable to you, that one person can actually control the outcomes of the cases by constitution of benches, and this probably was the mischief that the Parliament wanted to address.
If I may add, there is a judgment of this court and the judicial pronouncement on that as to what procedure would be followed by the Chief Justice to invoke jurisdiction of this court under Article 183. And it says where a bench, 3-member bench, 2-member bench, but a bench comes to the conclusion that there is a matter of public importance affecting fundamental rights, they may recommend to the Honorable Chief Justice that a bench be constituted. And the Honorable Chief Justice, after seeing the reasons that the bench has assigned for recommending, he may or may not, but at least he would recall reasons why he thinks he disagrees with the recommendations, or thereafter he can proceed. And so there is a judicial pronouncement on that.
In fact,
Sir, I'm sorry, since
may I say,
Honorable Chief Justice has said that we can only ask questions and not for you to respond immediately. So let me, with all due respect, ask a supplemental to what the supplemental put to you by my learned brother, colleague Justice Atar Minallah. It seems to me that the power to constitute a bench, which is the subject matter of Section 2, constituting a bench does not block the exercise of judicial power. It simply determines which is the bench that is to exercise judicial power.
Yeah.
But my question to you is that Section 3 seems to go beyond that. Section 3 is separate from Section 2. It actually blocks, it confers on the 3-member committee exercising administrative powers to actually block the exercise of judicial powers. It's not a question of constitution of benches. They can say, sorry, out, nothing further, matter ends. The question is this is not a question of composition of benches. That is power universally on them in terms of Section 2. The question here, it seems to me, is the very blocking of the judicial power itself. Can Parliament do that? Question is maybe noted.
And
you don't have to answer.
No, I'm not
Please
answering.
carry on.
I'm not answering.
The Honorable Chief Justice said you carry on with your
Your
submissions. Just note the
Honour
question.
this thing. I will add one thing to it. It also deprives of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is there, I am being condemned. I'm not being heard.
Who is
the party is not being heard.
Who is when you're using the word I, who is the I here?
Litigant. The litigant. Because
एक second, sir. Tahammul. The litigant, that leads me to another question. Your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
No, I am looking at Section 3.
No, I'm not talking that. I'm not asking a question of the petitioners. Do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You meaning your client.
Well, let me say this thing.
No, I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know,
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner and I'm saying this thing that we brought this petition
in
in the interest.
You got the answer, Now please proceed. I've got the answer.
Because in the interest that the law should take its course. The constitution must be upheld. And I am also saying that I'm sure with such eliminaries sitting there, the whole object is that first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Please. We are not going to platitudes.
I will not make a political speech. I'll refrain from that.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches. You were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your
I think
proposition.
your lordship is possibly not. I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Why it does not? Instead of Section 3 is a totally different thing. It takes away the powers of this honorable court. Why it does not? Instead of
Is it your
Let us
argument?
clarify.
Is it your argument
takes
that
away the
Section 3 affects the judicial powers of this court?
yes, sir.
Curtails judicial powers of this court because this court means the Chief Justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's not
I mean,
2 and 3 have to be read independently and separate.
now, please,
That too an exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing. Keep noting the questions and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
In fact, to be very, very
excuse
honest,
me.
I welcome this interruption.
Can I
For
ask
some
a question?
reason. Yeah.
Can I,
All right.
please? What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
We noted this down, and in fact, I will say that the Chief Justice powers will be whittled down. As if this law goes through, the powers will be whittled down. But we
मेरा मंथली है और शायद इस वजह से ही 1-2 दिन लेट से शायद हुई हो पेमेंट मुझे लग रहा है।
to form the benches is the rooster.
अच्छा सर जी, ये जो दूसरी वाली वीडियो है ना फेसबुक वाली, इसको काइंडली शेयर तो करवा दें यार। और ये थोड़ा सा मिसालेदार किस्म का है और ये चलेगी मुझे लगता है यूट्यूब फेसबुक पे ना, इसको जरा उठा तो दें।
The power of the Supreme Court has been curtailed or the power of the Chief Justice has been.
I think
That's the moot question.
the answer to that is that it's been noted, sir. It's noted, and I will only say this thing that Supreme Court. What is Supreme Court? Supreme Court is Chief Justice and so many other judges.
Wajah will be sitting here till 12 o'clock.
I know that, sir.
So आप जरा अपना argument
Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have
But if a
I have
committee-
noted this thing.
Yes.
Your lordship did not, sir. I would not be able to explain my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the parliament. About how the benches are to be
आगे
formed.
बढ़ते हैं.
I will go. I will dwell on that.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your
No, sir. I'm saying this thing that another 1980 rules, that power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your function. It is not the function of the parliament.
ठीक है, now let's proceed. We'll ask.
I'll argue on that.
Fayez sir,
That is the point which needs consideration. 5 is appeal. Yes, Mari sir.
on section 4.
On 4.
If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches, the question is this: that model, that aspect was not accepted by the framers of the present Constitution because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendment? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question. Please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ जी।
जी सर।
मैं बस सिर्फ सिंपल सा आपकी जो समझ आई मुझे आपकी कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है। सुनिए, ये सवाल तो सुन लें
जी जी
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत। ये आपकी बहस है ना सारी?
नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
ऐसे नहीं,
सुप्रीम कोर्ट
ऐसे नहीं।
चलिए बस नोट कर लें।
मैं नोट कर लिए कि जब सुप्रीम कोर्ट
आप जवाब ना दीजिए ना, बाद में जवाब दे, ठीक है? अदरवाइज तो आप आपकी मुश्किल काम हो
नहीं, तो मैं I'm quite I'm very patient. I have worked with all of you, sir.
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
Problem नहीं है. I understand what Shah Sahab is suggesting and saying, and we have mentioned this in many other cases. Yes, ma'am.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked. Independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you. Surely, the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
आप
नोट कर लें,
if I will really request my colleagues that they are making, including myself, are making your life impossible. No, please, no, you are very fine.
I'm learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act, and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section We are not even making progress. Please continue in your way.
आगे बढ़ते हैं, आगे
Let me say this.
Mr. Khwaja,
पहले ख्वाजा साहब सेक्शन 5 से आगे पढ़ लीजिए.
another question with regard to appeal. आप देखें हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत आर्टिकल 199 के लिए अपील प्रोवाइड की गई बिफोर 2 member benches. We are following it. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? बहुत अपील का राइट दिया है, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199 फिर आर्टिकल 183 84(3). तो ये क्या दोनों में?
Sir, it is
ये
not,
गलत
it
है
is,
तो फिर वो भी गलत
it is not, we'll answer this thing, that what Parliament can do and what Parliament can do many things. My Lord has said so. But there is the procedure provided, will answer that.
भाई साहब अभी जो आपकी जरूरत नहीं है, आप
I will not answer it.
पहले एक्ट को खत्म कर
Section
लीजिए.
5 से आप आगे बढ़ लीजिए.
Khwaja Sahab,
You have collected 100 questions.
Just here. The law reforms ordinance of
How you will
1972.
answer.
This is the question to you. Regulated right of appeal within the High Court itself, an intra-court appeal. Was there ever a clause on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clause is there only in respect of the Supreme Court. Law reforms ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent list, which is now no longer there, and also the clause was only in relation to Supreme Court. Question: is therefore the law reforms ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clause.
Mr. Noted, sir. And appreciate it. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person of this act, provided that the appeal under section shall be filed within 30 days of the commencement of this act. I'm not going to analyze it. I have my serious objection on this, and I will.
What you have to do, you're saying I'm not going to do it. You have challenged the law, you have to do, you have to challenge it.
Appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
As far as section 5 is concerned,
Is it good? Is it bad? First tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184(3), then why is this not they included in clause 2, whereby my 184(3) application will be disposed of?
The way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am. No, I am not. These are my reasons.
My lord, I have reservation on this.
You may have reservations. Tell us unconstitutional about it.
Then let me explain it to them, because if I start explaining it at this stage, it will take your time. But I will say this thing, that this section 5 should have also, this right of appeal should also have been given in section 2.
Should is different from ultra-vires a constitution.
It ought to have been given.
What then you go and move a bill in parliament. We are saying, are you opposed to section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे.
You have done this.
नहीं, ये नहीं, आप जवाब दीजिए ना. आपने petition लाए. This is not fair.
to make it more simple, you don't want your client to have a right of appeal.
No, so, sir,
You first say it's unconstitutional, it's constitutional, you're not saying anything, you just... यहाँ तो discussion होता है, sorry, not on. This is your job in office.
My Lord, may I say this thing that we divided the...
Please answer the question, is this constitutional or unconstitutional? I can't hear you.
वायरिस तो बताइए ना, वायरिस क्या है?
Hey, unconstitutional आपके जहन में और नहीं है?
Unconstitutional. Well, it's my personal opinion is this, that this section 5 goes beyond the powers which were there with the parliament.
So now formulate a contention on that. Please formulate a contention.
For the simple reason, my lord, if an appeal is to be provided, it's a substantive right. There has to be a constitutional amendment to provide an appeal under section 184(3).
Okay.
That, and this appeal to this act by an ordinary law cannot provide.
I can't seem to reconcile your, which I appear to me to be contradictory submissions. Please let me finish. Please let me finish.
Yes, ma'am.
On the one hand, you are saying, where will I go? Where will I go? Here, the parliament has given you a right. You say it's unconstitutional. So please don't make contradictory contentions.
I'm only saying this thing, that it's a good thing that the appeal be given, but the manner in which it has been given.
Please.
I'm saying this thing, that this one, the right of appeal given in this manner by an ordinary law.
We will not strike it down because of manner. You have to show us ultra vires the constitution.
It is unconstitutional, sir.
But saying so, no argument.
Our argument is this, that 184(3) is a substantive provision of the constitution. If
You are happy with no appeal.
Well, Lord, if a right of appeal has to be given, there has to be a constitutional amendment.
Okay, point taken. Move ahead.
I just have a question to you with regard to section 5 from what you have just said. Kindly read it again.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution.
Just kindly stop. So this order, the question to you has two parts. So the first part is this question, this order, which is now made appealable, is it a judicial order or is it administrative type of order? And if it is a judicial order, then how can Parliament, in exercise of the legislative competence conferred by Article 191, in relation to practice and procedure, confer a right of appeal? Because if I may, and this is the point, I apologize. My question has three parts. Because if I may touch upon what my learned colleague, Mr. Justice Mansoor Ali Shah, said recently, that this is recently, meaning in the hearing of the case, that anything that this law, the Supreme Court can itself do in exercise of rule-making power. Question therefore is, can Supreme Court confer a right of appeal in exercise of rule-making power of against the judicial order? If the answer is no, then it seems to me logically that Parliament also can't do it, because the two things are parallel. Therefore, question, is it therefore unconstitutional?
Unconstitutional.
You don't have to give an answer.
If the right of appeal had to be given through an amendment. Yes, next is right to appoint.
आप चाहें तो आप हमें लिखकर तहरीरी तौर पे भी जवाब दे दीजिएगा, ठीक है? अगर आप आगे अपना आर्गुमेंट चलाते रहें, जी आगे बढ़ते हैं। छह को पढ़िए,
Right to appoint counsel of choice for filing a review application under Article 188 of the Constitution, or party shall have the right to appoint counsel of its choice. I personally don't object.
Personally की बात कोई नहीं है।
I'm not objecting to this, because I feel that
okay, it's okay. Chali, let's get on with it. Section 6 is okay.
Application for fixation of urgent matters, where application pleading urgency or seeking in terms filed in a cause, appeal, or matter shall be fixed for it. My objection of this is again this, that this is a function of the Supreme Court itself, because this relates to the
Please
procedure.
tell us, is it ultra vires the constitution?
It's ultra vires.
Thank you.
I just have a question on you on this, on section 7. Now, section 7 really relates to what has been stated as the nitty-gritty of procedural law. I mean, this is really going, say, in a civil court, into the very depths of CPC, or the way we in the Sindh High Court have original side into the Sindh Chief Court rules original side. The question, therefore, is this. The legislative competence under Article 191, if it allows Parliament to go into so much depth into the very nitty-gritty of procedure of the court, then surely Parliament has an untrammeled power to regulate the court itself. The power to regulate, if I may adapt, is the power to destroy. Does this not effectively destroy the independence of the?
This was my very first point, which I said, that the functions of the Supreme Court have been virtually taken over.
Is this not contrary to the fundamental principle of the Constitution, trichotomy of powers? So where the legislative organ is intruding upon the nitty-gritty and the procedural aspects which have specifically been left to the Supreme Court under Article 191, is it not an intrusion in the boundaries created by the trichotomy of powers?
That is why I say 7 is ultra vires.
Khwaja Sahab,
Yes, sir.
I think there's a very crucial and important question. The jurisprudence of this court, developed till today, has only looked at aspect of independence of judiciary, that is, freedom from external factors. But there are two other extremely or probably more important factors that affect independence of judiciary, and that is internal independence and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional independence, where probably in the perception of the public or the Parliament, those powers exercised over the years by the Chief Justice under the rules, they actually eroded the internal and institutional independence. So when we talk about independence of judiciary, these two aspects that have been ignored till today, they are probably more important.
That will certainly answer your lordship. So, please, one question also.
Since we have just one section, can we just finish reading it?
Raja Sahab, if I may have a supplemental on what my learned colleague has said. Is it possible, is it constitutionally possible that if at all, and speaking for myself and with very great respect, perhaps I do not subscribe to that view that has been expressed, but I ask a supplemental question on it. Is it constitutionally conceivable that if there is such a concern about the internal independence of the judiciary, that the solution is to put the power in the hands of Parliament? Would that not violate separation of powers? Tomorrow, what is there to prevent, and this is a question to you, what is there to prevent Parliament from making a so-called law relating to practice and procedure and provide the federal government is hereby conferred powers to make rules and for the practice and procedure of the court? There is no end to it. Is if at all there is any trouble, and as I say, I have very deep regard and respect for my learned colleague, all of them, but in particular Justice Athar, is this really the solution? That is, okay, here's a problem internally to the, would that not violate? Well, I mean, no, as I say, it's constitutional. Is it even conceivable? I mean, where would that lead us?
With due respect, my lord.
ख्वाजा साहब ये एक बात सुनिएगा, एक क्वेश्चन
आप इसको खत्म तो कर लेना सेक्शन को। आप सॉरी टू से
आर्टिकल 8 खत्म कर दूंगी।
आप पढ़ ही नहीं रहे हैं।
मैं अभी पढ़ लेता हूँ सर। ये सवाल बड़े पर्टिनेंट,
आप हर चीज आप नोट कर लेना।
नोट कर भी दिया मैंने सर। करिएगा, मैंने शुरू में ये कहा था।
आप शुरू में क्या कह रहे हैं? आप आखिरी सेक्शन पढ़ लें।
मैंने शुरू में ये कहा था, आपने शायद इसका और जो ये आप कह रहे हैं, तो इंटरनल वर्किंग ऑफ द सुप्रीम कोर्ट है, उसमें किसी और का दखल नहीं होना चाहिए। ये अगर ये दखल अंदाजी होगी तो फिर ये सुप्रीम कोर्ट नहीं रहेगा।
एक बात और नोट कर लीजिएगा, आपने कहा सेक्शन 5 जो अपील है वो अल्ट्रा वायरस है टू द कॉन्स्टिट्यूशन, मगर एट द सेम टाइम व्हाइल यू आर रीडिंग सेक्शन 6 it is right of review. You say that you have no objection to it. Why? Because the choice has been given to appoint the council of his own choice. When the law is totally ultra virus, then how you can say that section 6 is okay with you?
My own view was that at times we have the rules are there that if a lawyer says that I am ill or I am out of the country or not well, you do allow in review.
You are declaring right of appeal ultra virus and right of review intra virus.
No, madam, what I'm saying is,
according to your own arguments.
The question is that you cannot provide a right of appeal,
but you can provide the right of review
under 184(3). If 184(3) right of appeal is given in accordance with the Constitution, then as far
फैज साहब फिर आप अपने लिए आप जरा सुन तो लीजिए ना। आप ये सवाल जो है जरा आप सुन तो लीजिए ना।
Does the petition that they have filed, does the petition talk about enforcement of the fundamental right or not?
The petitioner, my lord, proceeds on the basis that by conferred upon the Chief Justice under the Supreme Court rules have been curtailed or taken away, and that then results in this law being unconstitutional. It is not the case here that this act in any way prevents enforcement of any right.
Attorney General, one way of looking at it is the enforcement part, that whatever act has been challenged impedes the actualization of the fundamental rights. So perhaps it's interchangeably talking about infringement, however uses a different word. So if a citizen comes and says this particular act thwarts or impairs the actualization of my fundamental right, I'm coming to the court. So enforcement or infringement might be synonymous. One more thing, I think the question of public importance also is a threshold entry point. Suppose if we see, don't you think the petitioner will have to show that in order for it to be a question of public importance, there must be apparently that law must be against public interest. But suppose if it's clearly in favor of public interest, does it constitute a question of public interest? To become a question of public interest, it must apparently prima facie be something against public interest, and then you say, yes, it's a question. But if it's so obvious that the whole law is in public interest, for example, do you think there's a threshold to that effect, or there isn't any?
My first part of my submission, my lord, was that the question of public importance, my lord, when I pointed out that what this law does is it democratizes this institution, brings more transparency, structures the discretion, it actually advances that public interest. And therefore, they fail on that threshold, that count as well.
Attorney General,
my lord.
On my repeated questions, in response to my repeated questions, they conceded very explicitly that this is a good law. It enhances access to justice, and also, speaking for myself, it addresses a very, very big issue of internal and institutional independence. Now, in that context, when this is an admitted fact, the only question whether the parliament had the competence or not, kya jo 184(3) ki requirements hai, wo fulfill hoti hai, because there is no enforcement of fundamental rights.
My lord, if that is so, then these petitions have to be rejected on this basis alone, because insofar as legislative competence is concerned, 184(3) cannot be pressed into service.
So taking
If we'll let you, I think a lot of questions are coming up. We'll note, I'll try to make a point.
These are, my lord, please.
Well, अगर आप थोड़ा सा अपना continue रखें, I want to know where you're going, okay?
Attorney General, if I may ask you a question, is it in the public interest that Parliament, or for that matter, a provincial assembly, remains within the limitations that may be placed by the Constitution on Parliament or a provincial assembly? Is it in the public interest?
My lord, which fundamental right would it
Not
be
talking of
affected?
fundamental right. I'm talking of public interest.
Of course.
Of course.
Yes.
So therefore, if a law,
Again, this is happening, which I must, sorry, interject. I would, with you have agreed now here, I won't agree with you. I will say it may be unconstitutional, but not within the parameters of 184(3). There may be a lot of unconstitutional things going on in Pakistan, but it won't come within the parameters of 184(3). That is a fundamental point. That's my way of approaching it. Others have different ways of approaching it. So I think आप जरा चलें, फिर आप note कर लें सवाल.
I just, this part, I
Attorney
just.
General, if I may continue, sorry, if I may continue. It is in the public interest. I'm not speaking of any fundamental right. I'm only speaking of public interest. It is in the public interest you accept, and I think rightly so, that because we have a federal structure, Parliament and provincial assemblies must remain within constitutional limits, right? Whatever those constitutional limits are. So therefore, it seems to me to follow logically that if Parliament makes a law that is ultra vires, or a provincial assembly makes a law that is ultra vires, it is in the public interest to challenge that law. Because if remaining within the constitutional limits is in the public interest, then going beyond those limits and making an ultra vires law is surely a breach of public interest. What would you say to that?
That touches upon the legislative competence.
No, I'm talking of public interest.
Yes, but
Yes,
but
is it
any
in the-
law, a law
is
cannot
it
be
in the
struck
public
down on the
interest?
basis of just
Where
being public.
the challenge can be is a separate.
My lord, let's just take a step back. Any law made by any legislature, provincial assemblies or the parliament, would be a matter of public interest and importance. It is a law which is being enacted. Now, in order to examine that law, in order to assume jurisdiction to examine that law, we have to look at, in the case of Supreme Court, in Article 184, and the cases of High Court in 199.
नहीं, आप
Now,
देखिए, आप तो कह रहे हैं ना, मैंने जो नोट किया, हो सकता है मैंने फिर गलत नोट किया हो, आप तो कह रहे हैं कि this challenge fails on both counts.
Yes.
Public interest and this.
जी.
तो मैं अभी सिर्फ public interest पे देख रहा हूँ ना.
But
तो मैं आपसे पूछ रहा हूँ, I mean, speaking for myself, it seems to me that any law which is ultra vires, whether by parliament, whether by provincial assembly, meaning breaches the limitations, whatever they may be, imposed by the constitution, because the constitution is supreme. It is contrary to public interest. Has to be.
now let me just quickly address this, because this is a maintainability issue here, and I want to address that issue here first and foremost. The two conditions provided under Clause 3 or required under Clause 3 are connected. It has to be a matter of public importance with reference to enforcement of fundamental rights. Now, independently, any legislation, any statute, any rule or any regulation would be a matter of public importance or public interest for that matter. Now, in order for this court to assume jurisdiction, now this court does not assume jurisdiction under 184(3) on a legislature, on any law being enacted for want of legislative competence. It has to be ultra vires or violative of the rights, fundamental rights.
So you say that the word relating to enforcement,
With reference to the enforcement of.
that you say is the buckle that connects the two things.
That is the buckle that connects the two, and that is where it actually prevents, if I may say so, this court to examine constitutionality of a statute on legislative competence.
Is legislative competence not in the public interest?
As I said, Your Ladyship, this is something, legislative competence alone is something which can only be examined in one act.
Is it not a right that everyone has under the constitution?
My lord,
laws are made in a particular way.
Legislative competence, of course, as I understand it, what you have to see in the act when is an act of parliament, whether Article 70 read with the list permitted it or not, or whether there is a provision of the constitution which directly confers that power upon the parliament, whether that provision permits it or not. And if those provisions do not permit that legislature to legislate on that particular matter, then yes, this is a legislative competence issue and it is not permissible under 184(3).
So in your opinion, the law is good law, Parliament is competent to make the law, and every provision of the law is valid and does not in any way violate any provision of the Constitution. So then what happens? Again, I go back to the full court hearing aid, and you are given a right of appeal under that. So are they not then entitled to their right of appeal in the event that the court decides that these petitions are not maintainable? They cannot challenge it. And does that not go to the fact that once again you've put the burden on the court itself to decide when it wants to constitute a full court and block that right of appeal, and when it wants to constitute a smaller bench and allow that right of appeal?
And whether the act is in field or is suspended?
I think my justice colleague has raised a very valid point, and I was thinking about it during the break. If we read the right of appeal, first of all, it talks about an aggrieved person. I'm trying to envisage a scenario where one would be aggrieved. First scenario. Second thing is, we can, and this is permissible, read down legislation. We can, for instance, read into it that wherever there is a full court, needless to say, you cannot have a right of appeal over the full court. So that one can read down the legislation that those cases. But which right have we determined? What have we taken away from someone? Someone gets an extra right to challenge a judgment, if at all it's an irritation to us. Oh, now you have to have the appeal. Oh, now the review jurisdiction has been extended. So what are we doing? And it's not conferring this power to an executive functionary, to the legislature, to the president, or to anybody else. It may be nuisance value for us. Our reviews are going, our appeals are going, that sort of thing. What are we taking away? If the judgment is correct and in order, should we shy away from looking at it because someone files an appeal? Yes, it may bring in litigation into the court. That's the downside, may be said. But where is the aggrieved person? Who will be the aggrieved person be? The person affected. Because I think the 184(3), the whole intendment of that was for not for lawyers. It was not for the well-to-do. It was not for the multinationals. It was for the poor, the dejected of society. We have a whole chapter on the principles of policy, which no one bothers to, we don't read. Bonded laborers, transgender, women rights, children, they can't come to court. We can intervene, 184(3) can come to the rescue. So I was looking at things in that perspective. We have to see the whole entire constitution as a whole. We just stuck with one provision that somebody said, hey, please tell me how you aggrieved. I kept asking him, are you aggrieved? He says, no. They couldn't do it, you can do it. That's about the argument that I've understood so far. That's a valid argument on its own. Yes, to be addressed, for instance, the income tax ordinance has certain provisions that have been challenged before the High Court. Could we entertain it on 184(3)? After all, it is a legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But it is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route, get a 191 petition, come to the Supreme Court in 184. That is appellate jurisdiction. So we should read the Constitution and not just pick the words. We are just stuck with these words, two words also. Who's harmed by this? The only thing is you've taken away our power. You've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another same lawyer. Okay, person wants to waste money on another lawyer, do so. So his pocket will be lighter. What is it to us?
आगे बढ़े थोड़ा सा. If I may stop, sorry, take you back to what you were saying about, and I understand your point relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court, and That is, you say you accept that any law which is ultra vires is against the public interest, but you say the buckle is missing because it doesn't, it has to, it's not just legislative competence alone, but it has to relate to fundamental rights. So I was just
If I
wondering.
may rephrase it before my Lord formulates the question, legislative competence cannot be interfered with here.
No, I'm just saying, I understand that. So, ये मैं ही कह रहा हूँ. Yes. But breach of legislative competence contrary to the public interest. As until it is related to fundamental right, 184(3) cannot be. यही आपकी argument. So I was just wondering that the subject matter of this law essentially is the practice and procedure of the Supreme Court. Article 10A relates to due process. So surely any law relating to the practice and procedure of any court, but let's take the Supreme Court, which is ultra vires, surely that affects due process and therefore is directly relatable to a fundamental right. What would you say to that?
And that is where, when passing this threshold, of course, when a petition comes before your lordship, so before this court under 184(3), these are the two things which are to be examined at first instance. Now, once this threshold is met, then, and the burden is just discharged.
You Article 10A. It helps sometimes to refresh our memories.
For the determination of his civil rights.
Of his civil right, not the Supreme Court civil rights. आगे पढ़ें.
And obligations, or in any criminal charge against him, a person shall be entitled to a fair trial and due process.
It's nothing to do with the Supreme Court's due process. It's his. You have your right of appeal been taken away, your right of cross-examination been taken away, have your right of a statement under 340 been taken away.
So that's where then it takes me, my lord, and I was just addressing your question.
Attorney General, the subject matter is legislative competence in relation to practice and procedure. Surely, as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because it is ultra vires, it can't be due process.
So let's proceeding on this.
Whatever it says, whether it says
I'll go with it.
Chief Justice is masters of the roster or five.
I'll go with it, and let me just make my submission on this. I'll go with it. When somebody brings in, and let's assume, for the sake of argument, let's assume, and for a moment, if it is assumed that yes, it is a matter with reference to fundamental rights as well, then what has to be shown in the first instance is that this legislation fails to enforce or infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
they have not shown anything to say that there is any due process which they are entitled to under the existing scheme or the scheme as it stood prior to this act.
We made questions. You can continue, but I think we have our own views or opinions. आप चलें आगे.
Now
you have to persuade us, not we have to persuade you.
Just one question I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been dismissed under Article 185, another appeal would be available to the litigant before a larger bench. Would that law stand?
I would rather consider these.
Competence ki baat kar raha
hu. Let's consider what this law did. Maybe tomorrow that very matter comes before us.
So the question is
a second appeal. My lord's question is there is a second appeal would be.
Not at all. I am questioning the competence. The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, can be provided by ordinary legislation? So the example I gave you was an extreme example. The first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the Supreme Court.
I will add to this question. Is there any
और
provision
वो
in the
उसमें
Constitution
उसको
preventing
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो इनलार्ज किया, पहले एक अपील थी, अब हमने दूसरी कर दी है, तो इसलिए ये हमारी कॉम्पिटेंस में है. Would that argument stand?
Noted, my lord.
ये add
आप
कर-
बाद में जवाब दे दें, आगे बढ़ते
ऐड
हैं.
कर रहा हूँ उसमें दूसरी तरीके से. Is there any provision in the Constitution preventing the Parliament from doing so?
It's noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General,
My lord.
please you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically. And Article 4, Article 25.
My lord.
And subsequently in section 3 specifically talks about 184(3).
My lord.
How this can be
It does not.
proceeded
Three,
under
yes.
Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord.
And how that can be moved before the Supreme High Court under Article 199 of the Constitution.
My lord, I noted. My lord, now the question that has come before your lordship is whether this Act 2023 Act is covered under the definition of law, howsoever expansive definition, however expansively the term law is defined. My lord, Article 260 has two definitions. One is of an act of parliament and the other is of a federal law. Here we are dealing with a federal law. Article 260 defines a federal law. It says,
You say over here, law includes statute.
yes, yes. My respectful submission, law can only have one meaning as far as this provision is concerned. But even if it is given an expansive meaning, this act would surely be covered under the definition of law.
It's to be covered, then why didn't the Constitution say by an act of Parliament? Why did it use the word law? These words are not interchangeable. They are used in a very specific sense in different articles. And so you have to, the interpretation has to be given to the word law and not to just say, just because law includes legislation, so here it will be legislation alone. Law has a meaning, and if the Constitution wanted to say just by an act of Parliament, it would have used those words.
Your Ladyship, when we look at the provisions from where the Parliament draws its
Why did you look at 75(3)?
75(3) and 141 and 142 as well.
पढ़ लेते हैं जरा, उसमें दोनों लफ्ज इस्तेमाल हो गए.
When the president has assented or is deemed to have assented to a bill, it shall become law and be called an act of Majlis-e-Shura.
So law is what happens. What it is, the name of the thing is, you are a man. Your name is Mansoor Rahman. I would read it like that.
And the definition of federal law under Article 260 is, federal law means a law made by or under the authority of Majlis-e-Shura Parliament. Now, if we turn to Article 8.2, for the sake of this submission, where any law which is inconsistent with fundamental rights is void, Article 8.2 says, the state shall not make any law. Now, the state is not just the parliament. The state is the province, the governments, and the assemblies, and any authority which has power or is authorized by law to impose any taxes.
आप फरमा रहे हैं कि law, and you refer to the definition of federal law. You don't say federal law.
It does not. What I'm saying is,
I have a question for you. Suppose a provincial assembly under Article 191 law बना सकती है, बना सकती है?
Oh, 2000 के अंदर 2000 Supreme Court deals with that question. Yes, they cannot. Because the power with respect to legislation with respect to regulating the court's jurisdictions or powers flows from entry 55, so 191 or 175 too, for that matter.
I draw your attention to entry 58.
Relates to the federation also. Yes.
Kindly read it.
Matters which under the constitution are within the legislative competence of parliament or relate to the federation.
So therefore it seems to me, and I put it to you as a question, that actually entry 55 has nothing to do with article 191. The power that is specifically conferred on parliament to make statute law and in terms of article 191 is relatable to entry 58. Entry 55 has got nothing to do with article 191. And this connection, first of all, excludes the example that I gave of a provincial assembly making a law over here, right? And secondly, it establishes that here there is a direct grant by the Constitution, by a specific article of the Constitution on Parliament, as opposed to the general grant as conferred by Articles 141, 142, and so on. That's a general. This is a specific grant. Because precisely it is a specific grant, it relates to a specific entry 58. So I would put it to you as a question that entry 51 has no relevance for the present issue.
Entry
55 has no relevance. This is a matter between, and insofar as law is concerned, statute law, Act of Parliament, the connection is 191 and entry 58. I would say to you, entry 55 has got nothing to do with it. What would you say to that? Keep it in mind and move on.
Well, now, my lord, if my lord may kindly turn to Article 141. This is with respect to reference to the use of term law in Article 191.
Should be read with Article 260.
260.
Act of Parliament. So here the word is law, so you can
Yes.
read together.
And 141 and 142 also is in continuum, my lord. 141. Subject to the Constitution,
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों पर समाअत। चीफ जस्टिस काजी फायज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। तारीख में पहली मर्तबा फुल कोर्ट की समाअत पीटीवी न्यूज और पीटीवी नेशनल पर बराह रास्त नशर। निगरान वजीर आजम अनवारुल हक काकड़ का 5 रोजा दौरा अमरीका। न्यूयॉर्क में अक़वाम मुत्तहिदा की जनरल असम्बली के 78वें इजलास से खिताब और आलमी रहनुमाओं से मुलाकातें। मौसमियाती तब्दीली से मुताल्लिक अहम कॉन्फ्रेंस में शिरकत करेंगे। निगरान वजीर आजम दौरे में बैनुल अक़वामी ज़राए इब्लाग के नुमाइंदों से मुलाकातें और अमरीका के मारूफ थिंक टैंक्स का दौरा करेंगे। मुल्क भर में बिजली चोरों और नादहिंदगान के खिलाफ कार्रवाइयां जारी। मुलव्वस अफराद के खिलाफ मुकदमा दर्ज, मुतादिद गिरफ्तार, जुर्माने आयद। तकसीम कार कंपनियों का बिजली चोरी के खात्मे तक क्रैकडाउन जारी रखने का अज़्म। सहूलतकारी में मुलव्वस मुलाजिमीन के खिलाफ भी मुकदमात दर्ज कराने का ऐलान। स्मगलिंग की रोकथाम के लिए हुकूमत और पाक फौज की मुश्तरका काविशें। अवाम का निगरान हुकूमत और पाक फौज की कार्रवाइयों का खैर मकदम। चीनी की स्मगलिंग और डॉलर माफिया के खिलाफ किए गए इकदाम से इनकी कीमतों में कमी वाक़ई हुई है। ऐसी कार्रवाइयां जारी रहनी चाहिए, अवामी राय। इलेक्शन कमीशन का हल्का बंदी कमेटियों के काम की रफ्तार का जायजा। हल्का बंदी कमेटियां अपना काम हर सूरत 26 सितंबर 2023 तक मुकम्मल कर लें ताकि 27 सितंबर 2023 को इब्तदाई हल्का बंदियों की इशाअत को मुमकिन बनाया जा सके। इलेक्शन कमीशन डॉलर की कदर में कमी का सिलसिला जारी। 1 रुपए 27 पैसे सस्ता हुआ। इंटरबैंक में डॉलर 295 रुपए 53 पैसे पर पहुंच गया। पाकिस्तान स्टॉक एक्सचेंज में भी तेजी। 100 इंडेक्स में 110 से ज्यादा पॉइंट्स का इजाफा। दौरान ट्रेडिंग 100 इंडेक्स 45,866 पर ट्रेड कर रहा है। मोदी सरकार का मुल्क की बदनज़मी पर से आलमी तवज्जो हटाने की भौंडी कोशिशें। इंतखाबात से कबल सियासी मफाद के लिए मन घड़त ऑपरेशन की झूठी खबरें फैलाना शुरू कर दी। फॉल्स फ्लैग ऑपरेशन एक थिएटर ड्रामा। मकसद पाकिस्तान पर दहशतगर्दी का इल्जाम लगाकर मकबूजा कश्मीर से आलमी तवज्जो हटाना है। भारत सियासी मकासद के लिए पुलवामा ड्रामा रचाना चाहता है, जिसके वाज़ेह सबूत मौजूद हैं। नाज़रीन, ये थी अब तक की खास खबरें। सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों पर समाअत जारी है। फुल कोर्ट समाअत कर रहा है। चीफ जस्टिस काजी फायज की सरबराही में पहली मर्तबा तारीख में फुल कोर्ट की समाअत पीटीवी न्यूज और पीटीवी नेशनल पर नशर की जा रही है। आपको लेकर चलते हैं।
This is existing laws.
Yes,
We've given
but
continuation.
law.
Yeah.
And any other legal instrument having the force of law. Now, surely, judge-made law is law.
Yeah, Leonard Counsel.
With the greatest of respect, if it's observation coming from the bench, I have severe reservations.
Leonard, I'll respond to that
because it's not a question; it's a statement.
No,
I want to disassociate myself from this statement.
I know the basis of this question, and I will address it.
There is no such thing as judgment.
Leonard Attorney General.
Mr. Attorney General, kindly read clause 2 of Article 260.
Leonard Attorney General.
Clause 2 of Article 260 to padiye. Clause 2 of Article 260.
Which are 260? Yes.
Clause 2, Article 260.
An ordinance is included, yes. In the Constitution, Act of Parliament or Federal Law or Act of Provincial Assembly shall include an ordinance promulgated. Yes.
Yeah, that Leonard Attorney General, the Parliament and its supremacy is because of its representative character. Now, if there is a law, an act of the Majlis-e-Shura, and that is in conflict with a judgment of even a full court, whether that act of the Parliament will prevail or the judgment of this court.
My lord.
It will be the act of the Parliament.
And if there is a judgment which has been rendered on the basis of, and this is where the principle of legislative overruling flows from, that if there is a judgment expounding a certain provision of a statute or the rules, that judgment cannot be overruled unless the basis or the foundation on which that judgment came about is altered or removed, which is to say, if the law, underlying law is amended, then the effect of that judgment goes. And that is where, even if, for the sake of argument, the term law includes a judgment, if the underlying, if the rules which were expounded by your lordship in that judgment.
First of all, I didn't say judgment, I said case law. Judge-made law is different from judgment. That is precedent.
So Leonard Counsel.
And also, आप जो अभी बात कर रहे हैं, extrapolating from that, is the rule surely an interpretation of the Constitution or the establishment of a rule of constitutional law by the Supreme Court surely cannot be affected by Act of Parliament. It can only be if the Constitution is amended or the court itself changes its view. Classic example, right of abortion. Added to the Constitution, Roe versus Wade by the US Supreme Court. Taken away as egregiously wrong by in Dobbs versus something or another 2022. I think surely that is settled constitutional law.
My lord,
Please, if you don't mind,
I have to take your lordship.
Please proceed further. I mean, we will write a judgment, whatever we want to write.
Now, my lord, I will. My learned colleague will be recording the questions, noting down the questions, and I'll respond.
One thing, how I understand this. This is not my
Mr.
statement.
Amir Rahman knows shorthand.
This is not my statement. This is my understanding. The Act of Parliament can be considered as law as well, but every law cannot be considered as act of the Parliament. जैसे कि आप मिसाल लेते हैं, landlord can be landlord, but owner can be treated as owner as well as landlord. तो इस तरीके से ये जो legislation है, Parliament करती है, उसको आप law भी कह सकते हैं, Act of Parliament भी कह सकते हैं, लेकिन जो जजमेंट या केस लॉ से आते हैं या कस्टमरी लॉ होते हैं, उसको आप एक्ट ऑफ पार्लियामेंट नहीं कह सकते, तो इसलिए उसको कन्फाइन किया गया, लॉ किया
कह भी नहीं सकते my lord. और दूसरा एक और इसको just let's look at it from another aspect. Now 1980 is when these rules were made, and when these rules were made, if I draw your attention to order 11 को जरा
अगर हम बहुत ही pedantic approach ले
order 11
ये pedantic approach ले लें, ये rules किसने बनाए? किसने बनाए?
Supreme Court ने 1980
Supreme Court क्या होती है? नहीं, hang on. Now, if you go into that approach, Supreme Court क्या होती है? बताइए.
All the Chief Justice and the judges
sitting at home. No way. No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So it surely cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I'm not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My Lord, if I may. Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are people who died in prisons, condemned to death before their appeals came up for hearing?
This is our domestic affair.
No. With great respect, my Lord, it is not.
It is
Absolutely not, my Lord. With great respect, this is the right of the citizen. Litigants ka right hai. My Lord, with great respect, it is not. It can't possibly.
Learned Attorney General, what if the Chief Justice refuses to call a meeting of the full court and refuses the full court to amend the rules? Should the parliament not intervene in the interest of the litigants? That is exactly what has happened.
And here, if my lords may kindly turn to Order 11 of the Supreme Court rules. Order 11 of the Supreme Court rules. I'm just going to take this point forward. Order 11 of the Supreme Court rules. It begins by saying, save as otherwise provided by law. The full court, going by, let's say,
एक मैं आपको इसमें तसादुम दिखा दूं अब मौजूदा रूल्स में जो आइन से तसादुम रखती है, ठीक है? अपील is a right. Civil petition for leave to appeal is not a right. For an appeal, the rules provide 30 days, which is a right. For a civil petition for leave to appeal, you get lots of time, 60 days. I would say it violates the very concept of the Constitution. Maybe it's a mistake, but the other question would be, suppose can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose suppose tomorrow I refuse to fix any bench, what will compel me? At the moment there is stay order of reason, I said, nahin, hum chutti pe jaate hain, court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So the object is, there has been a problem, there has been successive addition of cases. We are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते, वो भी इख्तियार चीफ जस्टिस का है. 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000. हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, पर हम तनख्वाह नहीं लें स्टेट से. हम जब टैक्स पेयर हमें पैसे देता है, हमें काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है. तो ये अब इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं.
My lord, I just
जो आप पढ़ रहे थे कॉन्स्टिट्यूशन ऑफ बेंचेस का, इसको पढ़े ना, ये सेव एज अदरवाइज प्रोवाइडेड बाय लॉ.
जी, सो
तब तो कोई लॉ था नहीं
जी, उस वक्त नहीं था, बट ये रिकॉग्निशन थी कि लॉ प्रोवाइड कर सकता है कुछ.
नहीं, आपसे ये अभी देखिए,
उस वक्त लॉ नहीं था.
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
आपसे simple, are the 1980 rules law, come within the purview of law?
191 की definition क्या आप?
191.
No sir,
no, these are the rules.
These are the rules. the language says subject to the Constitution and the law, the Supreme Court will make rules.
What is the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the full court of this court left it open.
Now the law has been promulgated and this covers under this provision.
Yes, not just this provision, it is covered under 191. This only recognizes what 191 already provides.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation.
In what context, my lord?
In the context of definition of law. There are two primary law and the delegated law. And delegated law includes the rules.
No, we are looking at it.
The Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199, and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to parliament, there was a role of executive as well. That role was taken away. That role was eliminated, but the role of parliament remained. And, my lords, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not
language.
You have not argued on Article 142. This is the distribution of legislative powers.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make laws
with respect
to any matter in the federal legislative list.
Yes.
And if we go through Article 50, the legislative list of item 57, it is also related to
58.
58. उसके साथ 55, sorry,
55, yes,
jurisdiction and power of all courts.
So insofar as Section 5 is concerned, it is entry 55. With respect to other provisions, it is Article 191 read with entry 58.
Article 50,
Sorry,
item
why is
58.
it not coming under 55? It says enlargement of the jurisdiction of
It
the
does.
Supreme
That's
Court
what I said, sir.
and the conferring up thereon of supplemental powers. So it
what
has
I
given
submitted,
us
sir.
more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the Recodic judgment. 6.5 billion. Isn't that a big enough mistake for us to understand?
That's exactly what I've submitted. Section 5 is covered under entry
So
55.
you were trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American presidents. Why don't we quote the American president, which the Supreme Court of America says 20 minutes and nothing more? Now, you are not, please don't take questions. You just hear them, write them down, whatever.
Now, my lord, I just stick to the submission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
जब आप देखें हम आज से सुबह से कोई 150 cases की addition हो गई हो because of this case. We can hear this case for the next month. No other work will happen in the Supreme Court. If you want the system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो कहते हैं, अब आप नाराज हो जाएंगे, मुझे बोलने दे रहे हैं. पॉइंट्स ले हम नोट करेंगे. हम आपको सुनने के लिए बैठे हैं. आपने इतने मोटी चीजें दी, हम पढ़ लेंगे इनको.
Now I just quickly rush through my submissions and
Order 11, the use of the word law, the term law, you think it carries the same meaning as in Article 191?
Yes.
Thank you.
Now, my lord, if leaving this act out of Article 191 would render part of Article 191 redundant, where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So therefore, the principle, the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been.
Or you can call it a sharing of the burden.
Sharing of
It's
the
a
burden.
huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord,
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far as section.
Absolutely.
Absolutely. And because what it does is,
I don't trust them. That's the only other way. I can't trust them.
It is in this time when
we
we want the justice system to be more efficient. It actually helps when there are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships. And if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. 184.3 is rare cases which come before your lordships under 184.3. It's actually the appellate jurisdiction of this court, which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective. And Section 2 endeavors to do as much.
So if that was the objective, the law would again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My lord, if I may respond to this.
Yes, sure.
My lord, if the pendency goes down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might be.
Why not 10?
Zero.
But
this is what is being sought to be assessed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various judgments was not done, they would have not come up with this thing. So parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-vires of constitution, fundamental rights in 184.3. Otherwise, it can be ultra-vires of constitution, you do a 199.
Simple. And my lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law? Of course. Oh, you see, you are saying this is a law
if it repeals it, yes.
That this is a law affecting, having such a salutary effect. It is having this, that, and the other. So someone can say, "जी parliament का तो power ही नहीं है, तो ये law को repeal कर दे." या फर्ज करें अगली पार्लियामेंट आती है, वो सेक्शन 2 को फारिग कर देती है, वो कहती है जी चीफ जस्टिस का पावर है, वो दैट्स गुड इनफ।
माय लॉर्ड
सकती है, आपसे पूछ रहा हूँ।
जी
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा। मैं कंजेक्चर्स पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा। ये कानून आ गया, अब अगली दफा कोई केस लिया आएगा हम वो वाला भी देख लेंगे। मैं ओपिनियंस कभी नहीं दूंगा। आप हमारे या तो एडवाइजरी जुरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे। आपका काम है अपनी सरकार, अपनी गवर्नमेंट को ओपिनियन देना, हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म। हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा, भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे बहुत सारी चीजें। आप फोकस कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत। हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है, मेरी तो मुझे तकलीफ हो रही है, सुबह से 57,600 कोई 57,000 है, अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़, आप चला लें 1 महीना केस, हमें क्या फर्क पड़ता है? फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब आवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म। ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट हमारे 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे। आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है। मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है, ठीक है, वो एक अलग बात है, आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें कानून को, ये तर्क कर दें, मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे। कोई इख्तिलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है, हमें आपको परसुएट करने की कोई जरूरत नहीं, आप हमें परसुएट कर लीजिए, और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला।
My lord, my learned friend is recording the question.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
my lord,
I'm not engaging in theoretical argument.
my lord.
I'm trying to understand the basis on which you are defending the
My lord,
constitutionality of this law.
आपका सवाल.
So therefore, my question stands. Tomorrow, if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity, that is within Parliament's competence?
My lord, if that is so,
Learned
if it
Attorney
so
General.
happens,
Yes,
Learned
not
Attorney
conjecture. This is
General.
to
Learned
establish the
Attorney
principle.
General.
You accept
Learned
that?
Attorney
Absolutely,
General.
my lord. Absolutely.
Learned
it is
Attorney
in Parliament's competence. And if I may say
I'm
so, my
sorry,
lord,
you
my
have-
lord,
you
I have
provided assistance.
I have you know,
Your
as
answer is
Attorney General.
absolutely.
Ji, absolutely.
Yes.
Yes.
Mr. AG, to your right.
Ji.
Section 2, it's provided that the bench, constitution of the bench. Suppose bench is constituted. Who will assign the cases to the benches? Still, this power has not been given in the act. Again, there will
My
be.
lord, the committee is to determine its procedure, and then it, with regards how the meetings are to be, this committee itself.
Who will assign the cases that this case will be fixed before this bench? And one thing more, if two members, senior member comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta Registry for 1 month, for 6 months, or for 1 year. Is it possible?
My lord,
What would we do if this situation occurs?
My lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, which would have included when and how where and how the meetings were to be held, and the constitution of benches, etc. But that never happened because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so, with regret, was the first. My lord, this is exactly what under subsection 2 the committee is to do as the first.
We will regulate through rules. They will regulate this act through rules.
My lord, the committee will determine its procedure the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their statute of relevance, what their status is an SRO or as a rule or whatever may call it, but the committee can determine its procedure and be a procedure of the committee for the purpose of its functioning. Now, Section 3, my lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and which was asked when the petitioners were arguing that the committee is to first see whether the matter is, it has to come before the committee to examine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo moto powers either, because while exercising suo moto powers, it is either previously it was the Chief Justice who would then first determine whether the matter was of public importance and relatable to enforcement of fundamental and then constitute a bench. This is this tension which my lord had also while authoring
But
judgment,
this
rendering
doesn't,
judgment.
this doesn't answer the question whether the threshold of 184.3 is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?
My
Now,
question is,
there's a distinction between what is filed under 184
Learned
and suo
Attorney
moto, and
General,
that's why.
my question is, if the Chief Justice, just one person, as a master of the roster, could decide whether to take a suo moto or not, why not a committee?
Yes, and that is why my response was that
further
if
providing guarantees. And my only question is, are we not accountable to the litigants?
Absolutely.
The Parliament is the representative of the litigants.
So
If they
Attorney
want
General,
to change our procedure because they are not satisfied with our internal or institutional independence, that's their prerogative.
And
we are
if I
there
may-
to serve the litigants.
And if I may, my
Attorney
lord,
General, normally you see the cases would be marked by the Chief Justice, even if it's a 184.3. So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question is, earlier the Chief Justice would mark the case to somebody. He would certainly mark it himself. I mean, I as a judge would not hear any case unless it's marked to me. And then all it says is that instead of the Chief Justice, the committee marks it.
Section
So
3,
judicial
my
power
lord.
is not in any way impeded, because judicial power comes after the bench. is
Section
marked.
3, Section
No, you
3
see,
talks
Section
about
3
invoking of jurisdiction, and that is
Section
what I was
3
addressing.
specifically states that the committee would examine. Yeah, देखिए, the word used is
and that's what I was
examine.
addressing.
After for examination, if the committee is of the view that the question of public,
This is exactly
so
what
it's
the
a
Chief
judicial
Justice-
power.
Yes, yes, yes. So मैं
So
यही
how
कह रहा
can
हूँ,
the committee on the administrative side exercise judicial power?
मैं यही आपको कह रहा हूँ कि if you are minded to hold, कि ये जो ओवरलैप हो गया है कि एडमिनिस्ट्रेटिव फंक्शन और जुडिशियल फंक्शन को कंट्रोल कर रहा है, you would have to inevitably hold that going forward there will never be a suo moto exercise of powers, because that's exactly what the Chief Justice used to do. They would first examine it and then constitute a bench, और यही वो टेंशन थी जो आप पैराग्राफ 53
Please take one
में आपने
question
कहा
from
था.
this side, AG sir.
Oh, sorry.
The Article 184 begins with the word Supreme Court. What does that mean? Supreme Court means all the judges or only the Chief Justice?
It's what Article 176, your ladyship says, is the Chief Justice
184
and the
and-
judges of the Supreme Court.
184 I'm talking
जी
about.
तो 184 में जो सुप्रीम कोर्ट है, सुप्रीम कोर्ट को डेफिनेशन जो है वो 176 से फ्लो करेगी.
जी जी.
176 में सुप्रीम कोर्ट का मतलब है चीफ जस्टिस एंड ऑल द जजेस.
All the judges.
No single person
Yes.
is the Supreme Court. It's all of you who are the Supreme Court. So while exercising jurisdiction, अब ये हो सकता है कि आप ये कहें कि नहीं, ये सेक्शन 3 जो है ये इस तरह से नहीं होगा, इसको हम रीड डाउन करेंगे और कोई भी एक्सरसाइज सारी कोर्ट बैठेगी और वो पहले देखेंगे कि ये थ्रेशोल्ड मीट होता है या नहीं होता है, and then
You mean to say that
by committee, that could be
Mr.
an
Attorney
fair
General, Mr. Attorney General, the committee is constituted of 3 members to see whether the case do fall within the ambit of 184.3 or not. The litigant would be invited to argue, or that would be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with under Article 184.3, would it not be defiance of right of audience and the Article 10A and all other due process?
In continuation, and what remedy would be available to him, because this is an administrative order, it cannot be challenged in appeal except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss a petition at the administrative side. It's simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184(3) petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. It is just to look at the
My lord, ये जो threshold है administrative side पे day in day out basis पे हमें cross करना पड़ता है litigants on this side. जहाँ पे objection आ जाते हैं registrar के कि ये meet नहीं
I'll tell you what's been happening. Number of 184(3) petitions have come up that the office has put objections.
Yes.
Not the judge, the office.
Yes.
जी one very low.
बिल्कुल.
ठीक है उन्होंने objection लगा दी, not does not come within the
parameter. chamber appeal में जाना
पड़ता है. They've come to me some of the absolutely ridiculous kind of petitions. ठीक है, they're dismissed in my chamber against an appeal is filed. The fact that you don't make available 184(3) does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office says not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? 1 जज. उसके खिलाफ क्या अपील है? कुछ भी नहीं है. End of story. ठीक है, तो यहाँ तो बल्कि वो भी jurisdiction बढ़ गया है. वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पास हमें दे दिए हैं, उसके पास होना चाहिए, असिस्टेंट रजिस्ट्रार के पास तो रहने दें उसके पास, वो बेशक बेहतर तयन कर लेगा, जो खुश नहीं होगा वो अपील में होगा. अब तो ये तो बल्कि ज्यादा उसको अहमियत दी जा रही है रादर देन उसको निगेट कर रहे हैं. और राइट तो नहीं है 184(3) का राइट, आपके सारे महफूज हैं जो आइन देता है, जो कानून देता है. ये नहीं कि आपने 184(3) की पिटीशन डिसमिस कर दी तो वो 99 में आप नहीं जा सकते हैं या आप सूट नहीं फाइल कर सकते हैं, जो भी चीज. यहाँ तो लोग अजीब अजीब चीजें, जी मेरा इससे पैसे उधार है, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी. रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, हमने उसको डिसमिस कर दिया, इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट. आई डोंट नो what are we taking away? Back to the same question, what are we taking away?
इस वक्त क्या सिस्टम चल रहा है? 184(3) में सिस्टम क्या चल रहा है?
2 सिस्टम्स हैं. एक है कि जब कोई पिटीशन आती है, जब कोई पिटीशन फाइल होती है तो वो ऑफिस के इससे होके जाती है. रजिस्ट्रार ऑफिस वुड फर्स्ट एग्जामिन वेदर इट मीट्स द थ्रेशोल्ड और नॉट. इनफैक्ट उसके ऊपर जो ऑब्जेक्शंस आते हैं वो कहते हैं कि ये नहीं मीट करता, एंड दैट्स द एंड ऑफ द मैटर. यू फाइल अ चेंज अपील. So that is one route. The 184(3) का दूसरा है suo moto. Now, this provision, in fact, cures the problems in the process on both counts. First, 184(3) की जो registrar ये power exercise कर रहा था, that power has now been given to this committee, the 3 senior most Chief Justice and 2 senior most judges.
You see, the power of registrar could be appealed in chamber, but in 3 members committee where the appeal lies,
which is the 3 judges, my lord.
3 judges.
ये बात ठीक है कि उसमें ये बात हो सकती है कि जी उसकी कोई आपको जो है वो फिर आगे हेयरिंग नहीं होगी, हेयरिंग नहीं होगी. मगर
जी साहब आप ये बता देना अगर 2 जजेस या 3 जजेस बेंच चल रहा है जैसे कि पुराना सिस्टम है, उसमें एक अगर 3 मेंबर समझते हैं कि दिस इज अ केस ऑफ पब्लिक इंपॉर्टेंस, वो रेफर करते हैं ऑनरेबल चीफ जस्टिस को, और जस्टिस इनकार कर जाता कि तीनों से एग्री नहीं करता. He has all the power, more power than 3 judges sitting in the court. The Chief Justice alone, sitting in a chamber, can undo this.
And the suo moto particularly, उसमें तो और ज़्यादा फिर problematic है, because उसमें तो खुद ही कर रहे हैं, वो खुद ही examine कर रहे हैं.
3 में भी the process is that if the committee thinks that it's a matter of 184(3), they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe, or wherever. It's not throwing out the list.
And my lord, as my lord the Chief Justice has just observed, it is not that other than 184(3), the constitution of this country or the laws of this country do not provide any remedy.
May I add to this?
My lord.
All that the committee will be doing, raising an objection.
Yes.
Objection to the effect, and that is for us internally to provide a appeal against.
My lords can suitably amend the rules. And
again, the question is that since 1980 had not amended our rules, that is why the parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the parliament to do it for us. And everyone, there's consensus that this is exactly, अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, पार्लियामेंट ना करती, आप कर लेते. But what when we are refusing to do that? And that is exactly what has happened.
Being 43 years.
This act simply says that we've not been doing our job earlier.
That is it.
And it's saying we'll do it for you because you've been sleeping all these years.
You were too polite to say that.
My Lord, we have section 4.
Read that.
Section 5.
अभी तक जवाब नहीं आया.
जी, वो आपने जो बात कही कि जी अब फुल कोर्ट अगर बैठेगी तो उसमें उस राइट ऑफ अपील का क्या होगा?
पहले क्वेश्चन तो ये है कि राइट ऑफ अपील कॉन्स्टिट्यूशनल अमेंडमेंट के बगैर कैसे आ सकती है जब 184(3) is a constitutional provision and it specifically it does not provide a right of appeal. Where the right of appeal was sought to be provided, it was provided specifically in the constitution. So aren't you adding to the constitution or amending the constitution without an amended
Mr. Attorney General, entry 55 says that we'll confer, enhance your jurisdiction to एक और 84 की अपील बना दी है. तो enhance
185 की भी फिर एक और अपील बन सकती है.
बन सकती है. सेकंड अपील तो है, हमें वैसे भी बताया हुआ है.
Speaking for myself, Learned Attorney General. Learned Attorney General, speaking for myself.
Why not then a third appeal or a fourth appeal? Or a fifth appeal.
Obviously, it's the parliament. Parliament won't do absurd things, and of course,
it's not a question of absurdity because this undercuts the review, the whole concept of review. The finality of judgments for res judicata is regarded as one of the most fundamental principles of the administration of justice.
Surely does.
Exception. No, अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया.
नहीं, infinity नहीं है. Obviously, you're talking about the parliament here. You're not talking about.
आप बात फिर आ जाती है conjecture और theory और ये और वो बात principle की हो रही है. असूल समझने की है ना. एक दफा एक बार को concede कर दिया जाए, accept कर लिया जाए. In principle, then there is no limit. And therefore, if there is no limit, the question to my mind arises that therefore the power does not exist.
Lord,
this is the
great
point.
respect. I would
Again, a review jurisdiction भी है ना. अब review jurisdiction का क्या concept है कि Supreme Court में finality हो गई. अब आप maximum में review कर रहे हैं.
With great respect, when it comes to even on this plane, and I submit that entry 55 sufficiently covers section 5.
Can you go to the next point?
I'll only add to this, Learned Attorney General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here the appeal has been provided in 184(3), which is our original jurisdiction. And it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And
so I don't see how.
And in a context where this court becomes the first and the final court in the same proceedings.
Are you done?
My Lord, to this extent, and I'm just going to conclude my other two submissions. And I have placed on my paper book the judgments of in Baz Mohammed Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my Lord. My Lord, section 6 now, right to.
There was one concern also expressed by Justice Aisha Malik, which was that if we follow this procedure, then when the full court meets, then the appeal goes away. एक ये भी point था, इसको आप कैसे address करेंगे? Because I mean, one answer could be कि if the wisdom of all is such है, तो फिर naturally सब लोगों ने सारे एंगल देखे होंगे. आप कैसे address करना चाहते हैं?
उसमें एक ये बात है एक ही बात है, मैंने अपने रिटन सबमिशंस में ये कहा है कि आप इसको टू दैट एक्सटेंट रीड डाउन कर लेंगे,
इस हद तक रीड डाउन करें
जहाँ पे फुल कोर्ट होगी नेचुरली अपील
आप 4
जो
और
है वो
5 को
obliterate हो
harmonize
जाएगा,
अगर कर
बट
लें,
आप उसको ये कर सकते हैं, सॉरी सर, जस्ट
I'm just saying if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
My lord,
That's
ये अब
quite
15
simple.
बैठे हुए हैं, so मैं जैसे just will say, so if it was in original proceedings, it was a bench comprising of 7 lordships on this side, the appeal would have come before the remainder 8 judges because it had to be a bench larger than the bench hearing the original appeal. In this case, we are before your lordships in original jurisdiction, full court.
इसमें ये जरूरी नहीं है कि one jumps from 5 member to full court. फर्ज करें अभी 15 जज हैं, ठीक है ना, फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटिशन आ जाती है, 9 member बेंच बन जाता है, फुल कोर्ट तो नहीं है.
My lords would be mindful of
बात
this.
सुन, अब ये हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है तो ये खराब और वो खराब और ये खराब. फर्ज करें 3 member कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9 member बेंच बना देते हैं.
My lord,
आप देखिए ना, आप इसको एड्रेस कीजिए ना, ये ऐसी बात नहीं है कि जी द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया. आप
मैं what I'm submitting is that now it's a duty cast हो गई है इस कमेटी के ऊपर.
पर उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना. नाउ यू पुटिंग द ड्यूटी ऑन द फुल कोर्ट, तो कोर्ट तो फिर अपनी मर्जी पर ही चल रही है ना. व्हेनेवर इट वांट्स टू डू समथिंग और राइट ब्लॉक करना चाहेगी. What you are saying is that substantive right that you have created under the statute is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं. तो फिर आपने ये राइट दी किस मकसद के लिए?
8 member बेंच बन जाए, 9 member बेंच बन जाए, राइट ऑफ अपील खत्म हो गया.
So let me just
I think what we can do is we can logically interpret the legislation. Now, for instance, when this case was first being heard, it was an 8-member bench. There were not enough judges, still aren't, to have heard an appeal, theoretically speaking. Yes. So, unless the bench, the very first day it sat, it decided to strike out this law, that's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them. There aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct? Yes. So when we are concerned now, we should have been concerned earlier too. So वो तो गई.
Actually, जब वो CMS थी फुल कोर्ट के लिए जब आर्ग्यू हो रही थी, उस वक्त ये सवाल बकायदा उठाया गया था कि आप कह रहे हैं फुल कोर्ट बनाई जाए, आपको तो कहना ही नहीं चाहिए कि फुल कोर्ट बनाई जाए, आपको तो कहना चाहिए this matter should be heard by lesser number. वो CMS क्योंकि वो hearing पे नहीं गई,
but the burden at the end of the day was on us.
Question was in fact put by me, and so therefore it's not that the question was not there.
My lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशिप पढ़ने के बाद महसूस तो ये हो रहा है कि जब ये पिटीशन ली गई उस वक्त तो यकीनन बिल था. इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था. बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है. अगर ये इनफील्ड होता तो शायद 8-member बेंच उस वक्त भी ना बनता. इसका मतलब ये कि हम एक्ट को मान रहे हैं. अगर हम बेंच पे एतराज करें इसका मतलब हम एक्ट को मान रहे हैं. और अगर एक्ट सस्पेंड है फिर तो अगर 8-member बन सकते, व्हाई नॉट फुल कोर्ट?
So मैं इसका brief एक response दूं and then followed by a detailed response in writing. Briefly put, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench.
मिस्टर अटॉर्नी जनरल, इसका मतलब है पार्लियामेंट फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती।
in cases, in circumstances में ये हो सकता है, जैसे अभी भी है।
repercussions तो सोचिए आपकी बात की कि यही प्रिसाइसली सवाल है कि इस लॉ की इस सेक्शन की वजह से।
So let me put it differently.
Now full court कभी बैठ ही नहीं सकती।
नहीं, full court आप बैठेंगे।
In Article 184, questions which are the most important question that can ever be raised before the court.
In exceptional circumstances, it might be so. But does that is that enough to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time, it will be saying that it's so important that a collective wisdom will prevail. So there is no, I mean, doesn't really, it can be easily.
It can be reconciled. My Lord, Section 6, right to appoint.
Section 5 can be read down.
My Lord, to that extent, my Lords can hold that in exceptional cases and when a situation this sort arises, that be so.
Right of appeal पे substantive right नहीं है जो statute।
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not, and all of that has happened under 184. With great respect, with great respect. And Steel Mill is a classic example. Steel Mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How many of those were full court judgments?
Well, Lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना।
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है।
यही तो point है कि एक तरफ आप कह रहे हैं हम right of appeal दे रहे हैं in order to address precisely these kind of things. दूसरी तरफ कह रहे हैं कि चलो full court बन जाए तो बन जाए।
Full court बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप kindly जरा थोड़ी सी
नहीं, there might be issues in time.
Implications of your submission तो kindly देखिए।
मैं उसको ये इस तरह से आपको कहता हूँ कि
Attorney General साहब, let's be, we are all grown-ups, right?
Attorney General साहब,
can I just the problem arose. I think thousands of articles have been written. Lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say. There has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused. Jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we are concerned about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did recodic. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and place it at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary, they'll say, what are you talking about? Independence of judiciary, independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy. We don't understand the repercussion of things. Fine. I'm not saying that judges who decided that they did what they thought at the time, how they were assisted according to their conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction You know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review unanimous, because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस लेजिस्लेशन की भी जरूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए, हमारा प्रॉब्लम ये हो गया ना, अन्ना बहुत बड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई, मान लें गलतियां हुई हैं, ठीक है. हमने ऐसी ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को, मान ले गलती की है, ठीक है. अदरवाइज आइन की कोई हैसियत नहीं है. अगर जज मेड लॉ हम उसको रख लेंगे अपने ऊपर, तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको, क्योंकि मैंने हल्फ नहीं उठाया है. The minute I say that, please file a reference against me that I'm violating my oath of office. If I say even this, I will endorse these subsequent acts. मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं पता उनको क्या मसला हो रहा है, उनको हमारा फिगर पड़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 पिटिशंस आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं. वो कहते हैं भाई हमारा केस चला के खत्म कर लें. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. But what are we doing? What are we taking away from him? Focus on that.
One thing, my lord.
And
Section 6, my lord.
इसमें अटॉर्नी जनरल साहब लॉ रिफॉर्म्स ऑर्डिनेंस के तहत there's a right of appeal. लेकिन कई cases में, depending on the issues, the high courts constitute larger benches, and therefore that right of appeal is not available. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है, 184.3 is discretionary. Now, यहाँ पे जितनी बात हुई है, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज हैं, वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में कि वैसी सिचुएशन आ जाए तो a judge from the High Court can be asked to act temporarily as judge of the Supreme Court. तो वो आपका एक्ट कहता है कि larger bench will hear the appeal. So add one judge. This is larger bench. Appeal is there. No problem. I think problem is solved by the Constitution.
The remaining judges would be the same. फैसला तो वही आएगा.
This was just like review.
आपने conclude कर लिए.
My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases under section 7.
Provision of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
My lord, at one end, now my lord would have to
देखिए
see
हम सारी बात चले ठीक है, मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं, उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, you going back up, what do you expect us to do then? The whole will be gutted.
how many cases would there be, my
And no limitation period is here.
ये तो आप मत करें ना।
My lord,
ये थोड़ा
I
सा
think what has been
थोड़ा सा ख्याल रखा करें ना। आप रखिए, आप लाएं
what the parliament has,
चलो ठीक
my
है।
lord, what the parliament has tried to address here is
So you see, it is very open-ended. Prior to the commencement of this act, so it will go to 1947 or what?
जितने 185, 73 से शुरू हो जाएंगे।
My lord, 1947 तो नहीं, 75 में पहला हुआ था।
एक बात है, बात इसमें is open-ended ना।
And then
You have fixed a limitation of 30 days for filing appeal prior to commencement of this act. Means all previous decisions, all persons can come to this court within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came
ये
actually.
बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनैक्टमेंट के बाद अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होंगी because the law was
सस्पेंडेड।
Okay, I see. Couldn't have taken effect.
फिर एक और छूट जाएगा ना। ये बताइए, जितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया है, can the people of this country file appeals and have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do
And my
we
lord,
fear
just
if
to
it's
Otherwise,
history,
we'll
I
be
think
brushing things under the mat.
1975 Manzoor-e-Ilahi was the first case under 184(3), and thereafter, after 13 years, it was Benazir Bhutto case, 1988. ज्यादा जो jurisdiction exercise हुई है वो perhaps
But where
पिछले
do you
15
draw
साल
the
में
line?
हुई है।
Where do you draw the line? I mean, the question is, if there is transparency, then let it be.
Let it
Why
be.
brush something under the mat and look into some? Why?
My lord,
Let's undo Federal Shariat Court Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because everybody's dead or whatever, long past. Go on.
My lord, I would conclude my submissions with this. I have the written submissions along with Reliance's. I have noted down one question जिसका detail में
ये
हमने
section
submission
6
करना
पे
है।
भी बता दीजिए learned attorney general
My
ये
lord.
जो आपका
Right
right
to counsel.
Yes, because it
Now-
is already covered under Article 188 of the Constitution.
उसमें order 26 है।
Power of the review.
जी, order
So
26.
you have said that the party shall have the right to appoint counsel of its own choice.
पहले जरा my lord का 188 पढ़ लें जो refer कर रहे हैं my lord।
188 is the Supreme Court shall
पढ़ लें जरा।
have power subject to the provisions of any act of parliament and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it.
Yes.
So this power under the power of review.
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों पर समाअत। चीफ जस्टिस काजी फाइज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। तारीख में पहली बार फुल कोर्ट की समाअत पीटीवी न्यूज और पीटीवी नेशनल पर बराह रास्त नशर। निगरान वज़ीर आज़म अनवारुल हक काकड़ का 5 रोजा दौरा अमरीका न्यूयॉर्क में अक़वाम मुत्तहिदा की जनरल असेंबली के 78वें इजलास से खिताब करेंगे। अनवारुल हक काकड़ आलमी रहनुमाओं से मुलाकातें और मौसमियाती तब्दीली से मुतालिक अहम कॉन्फ्रेंस में भी शरीक होंगे। बैनुल अक़वामी ज़राए इब्लाग के नुमाइंदों से मुलाकातें और मारूफ अमरीकी थिंक टैंक्स का दौरा भी शेड्यूल का हिस्सा। मुल्क भर में बिजली चोरों नादहिंदगान के खिलाफ भरपूर क्रैकडाउन जारी। तकसीम कार कंपनीज की जानिब से मुख्तलिफ शहरों में कार्रवाइयां। मैप्को रीजन में बिजली चोरी के मजीद 136 कनेक्शंस पकड़े गए। केस्को टीमों की जानिब से भी भरपूर ऑपरेशन। 42 नादहिंदगान के कनेक्शंस मुनक़ता। 6 अफराद गिरफ्तार कर लिए गए। गेप्को रीजन में 611 बिजली चोर पकड़े गए। 4 करोड़ 70 लाख रुपए जुर्माना। 503 अफराद के खिलाफ मुकदमा दर्ज। स्मगलिंग की रोकथाम के लिए हुकूमत और पाक फौज की मुश्तरका काविशें। अवाम का निगरान हुकूमत और पाक फौज की कार्रवाइयों का खैर मकदम। चीनी की स्मगलिंग और डॉलर माफिया के खिलाफ किए गए इकदामात से कीमतों में कमी वाक़ हुई है। कार्रवाइयां जारी रहनी चाहिए, अवामी राय। डॉलर के मुकाबले में रुपए की कदर में मुसलसल बेहतरी। इंटर बैंक में डॉलर 1 रुपए 30 पैसे मजीद सस्ता। कीमत ₹295.50 हो गई। ओपन मार्केट में डॉलर की कीमत खरीद 294 और कीमत फरोख्त ₹297 है। इलेक्शन कमीशन का हल्का बंदी कमेटीज के काम की रफ्तार पर इत्मीनान का इजहार। कमेटीज को हर सूरत 26 सितंबर 2023 तक काम मुकम्मल करने की हिदायत। 27 सितंबर को इब्तदाई हल्का बंदियों की अशात को मुमकिन बनाया जाएगा। तर्जुमान इलेक्शन कमीशन। इलेक्शन कमीशन में आम इंतखाबात के लिए इलेक्शन मॉनिटरिंग कंट्रोल सेंटर तश्कील। जदीद तकाजों पर मबनी सेंटर में पहली बार व्हाट्सएप का इस्तेमाल करने का फैसला। इलेक्शन मॉनिटरिंग कंट्रोल सेंटर चीफ इलेक्शन कमिश्नर के विजन के मुताबिक डिजिटलाइज किया गया है। इंतखाबात के अलावा इंतखाबी मुहिम समेत हर इंतखाबी अमल की मॉनिटरिंग की जाएगी। इंटरनेट से मुतालिक मसाइल वाले इलाके भी अलग हिकमत अमली बनाई जा रही है। इलेक्शन कमीशन हुकाम की सहाफियों को ब्रीफिंग। और एशिया कप के फाइनल में ना पहुंचने के बावजूद पाकिस्तान आईसीसी वनडे रैंकिंग में पहली पोजीशन पर आ गया। जनूबी अफ्रीका के हाथों शिकस्त ने ऑस्ट्रेलिया को 30 नंबर पर भेज दिया। भारत की टीम दूसरे नंबर पर मौजूद। बिस्मिल्लाहिर्रहमानिर्रहीम, अस्सलाम वालेकुम। आप देख रहे हैं पाकिस्तान टेलीविजन न्यूज। मैं हूं नाज़िया खान। हेडलाइंस आप जान चुके हैं। सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों की समाअत जारी है। आइए आपको लाइव लिए चलते हैं।
Am I bound by the Supreme Court rules, or rules are in aid of administration of justice, and rules bind the council and the litigants but does not bind the court? What is your position on that? Am I bound to follow the rules of 1980? I mean, like for instance, Order 33 says I can condone delay, I can do various things. So it is there to be followed by litigants and counsel, but there may be cases of extreme injustice where we may overlook. For instance, in criminal matters, we rarely even ever dismiss things on grounds of limitation, though it is provided it has to be filed within a certain period of time, because the liberties of the subject, we haven't given a decision on it. So, but I think rules are really to show us, guide us, not really to bind us.
Actually, rules acknowledge this. Order 33, Rule 6 actually says so.
That, overall,
it says that the rules shall, nothing in these rules shall be deemed to limit or otherwise affect the inherent powers
end
of the
day,
court.
it's not so important,
It's practice and
significant
procedure,
document.
my lord. It is practice and procedure. These are all.
वो भी हमने order 47 को connect कर दिया and civil proceedings is a court के साथ. So these are not, I mean, these are not like ironclad things that we cannot. We'll see where the justice of the cause lies, and of course, it doesn't mean they're totally irrelevant. So we will see when it's appropriate. It may be a good case, it may be a bad case. I don't know. So, आपका you conclude या कुछ और रह गया?
My lord, I have concluded.
Attorney General,
in writing.
Question. If I may ask a question. If you are not bound by the Supreme Court rules in terms of whatever the Supreme Court rules say, but we are bound by Act of Parliament in regard to our own practice and procedure, do you think that is a constitutionally viable position?
My lord,
then if these rules are made by the full court on the administrative side, and any particular bench can say, well, goodbye to the rules, why shouldn't that bench have the right to say goodbye to the act?
My lord, my response to that would be that both the preamble, from which we draw those salient features.
No, I think the thing is
the
that
independence
when the
of
Supreme Court is sitting as a court of law, what is it bound by? If it's not even bound by its own rules, why should it be bound by Act of Parliament?
My lord, the rules,
say then maybe
say
that particular bench can say, well, we don't recognize section, what is it, section 6, and another bench can say, well, we recognize section 6.
My lord,
I mean, why should not your this law that you're defending,
I think
not that be put in the same category vis-a-vis our own rules? If we are not bound by one, why should we be bound by the other?
As I view it, I think priority number 1 is constitution. Number 2, in scale of importance, is law. Number 3 is rules. Then come regulations. Then come notifications. Then come whatever you want to, instructions. So this is, in my mind, I go by that approach. I may be wrong.
My lord, the rules, actually, Rule 6 of Order 33 itself.
I think the Constitution actually
views of process नहीं होगी, ends of justice को meet करने के लिए you're not bound by.
Attorney General, the rules actually come out of the Constitution, and Constitution says the court has to be regulated. So I think that, in my opinion, certainly the rules regulate the affairs and we're bound by them. And they might be in the trajectory starting with the constitutional law and the rules, but all of them are binding, and that's how the system works.
And my lords would also acknowledge that this is not a case where Article 199 per se has been challenged on the basis of it being violative of salient features for that matter. Of course, even if that was so, both 191 and the preamble from which the salient features flow were enacted at the same time. It is not a subsequent amendment where relying upon Kesavananda Bharti or DBA Rawalpindi matter could have proceeded. So when the preamble, when the constitution was being made, 199 has not undergone any amendment ever since. So therefore, my lord, my respectful submission would be that this act, my lord, be declared constitutional and the petitions be rejected to that effect. And nothing in this act in any way undermines the independence of judiciary, or nor has any externality been introduced where any other organ of the state or branch of government has been given any role whatsoever.
Hopefully, these are your final words. Hopefully,
I'm concerned. My lord.
आपने कंक्लूड तो कर लिया, बस एक क्वेश्चन पूछना था कि अगर फर्ज करिए कभी इसको हम अल्ट्रावायलेट डिक्लेयर कर देते तो बात खत्म हो, लेकिन अगर इसको हम कहते हैं कि वैलिड लॉ है, वैलिड लॉ हो जाएगा वहां से जब ये बना था। इन बिटवीन जो फैसले हुए हैं, व्हाट इज द फेट ऑफ दोज डिसीजंस? अगर वैलिड करते हैं तो फ्रॉम दैट डेट होगा, तो फिर क्या होगा? इसके बारे में आप बता दें।
They become past and closed transactions in several instances in the past where a similar situation or a situation arisen where a legal position had changed, but cases were decided or transactions had happened. The courts protected those under past and closed transactions. So that would be the effect to matters which should decide.
Can the committee not retrospectively, suppose if the law is sustained, can the committee not retrospectively grant permission? A bench was constituted, assumed as if by consent. Let's put it like that. I don't know if that's possible
cases
or
which
not.
stand decided, they stand decided. And that extent is past and closed.
अगर कोई बहुत ही ऐसा unusual case आ जाए, I don't know.
My lord, I don't know where the line would be drawn, but insofar as
I think
जी मैं इसको भी एड्रेस कर दूंगा।
ड्यूरिंग द पीरियड की बात हो रही है ना, जो केसेस इस दौरान जो हुए फैसले हो गए, उनका क्या बनेगा?
सो जो केसेस लिस्ट अब पेंडिंग नहीं है और वो डिसाइड हो गए हैं केसेस
ड्यूरिंग दिस पीरियड,
जी ड्यूरिंग दिस पीरियड, उसको अब आपको देखना होगा कि उसको आप पास्ट एंड क्लोज में प्रोटेक्ट करते हैं जो फैसले हो गए।
इतना पास्ट नहीं हुआ, अभी की बात है
वो। I think that is something that my lord would have to see if my lord wish to protect them.
Thinks of all the angles. This is possibility, that is possibility. So this is a possibility. We're just airing it. We don't know the answer.
उसमें दो चीजें हो सकती हैं, एक तो डिफेक्टो डॉक्ट्राइन को हम देख सकते हैं, दूसरा राइट ऑफ अपील प्रोवाइड हो जाएगी, so they can जिनके
as far as 184(3) is concerned उसकी होगी, जिनकी नहीं थी 184(3) वो तो सिर्फ बेंचेस की कॉन्स्टिट्यूशन तक रह जाएगी बात, उसमें आप देख सकते हैं कि वो तो
It won't be classic. देखिए दो किस्म के होते हैं, एक होता है classic quorum non-judice, ठीक है? This won't fall in that category. It will be simply a procedural lapse. Whether a procedural lapse will affect the outcome,
the cases which stand
I don't know. I mean,
if I may be
क्योंकि एक तो होता है ना substantive right किसी की, कहीं बोले आपका क्या right किया?
वो decide हो गए cases, वो past and close।
नहीं, past and close का लफ्ज क्या अगर हम कहें, देखिए एक होती है जो substantive right has been taken away. भाई okay, these three didn't hear it, those three heard it. आपको क्या फर्क पड़ा इससे? Are you with me? So I'm just thinking aloud.
Understood. So it does not, let's say, substantive. There's no it's substantially कोई offend नहीं किया किसी right को, कोई it was a matter of procedure.
और अगर कोई जैसे कहा कि कोई बहुत ही चीज हो गई ऐसे, वो रिव्यू तो पड़ा हुआ है फिर भी, और ये अपील पड़ी हुई है 184 में।
Yeah. And in any event, it was a bench comprising of your lordship.
No, we don't want to kind of create a situation where things don't function. So भाई वो उसको क्या पड़ेगा? चलो भाई आपने मेरा अदालत ने सुन लिया या सरदार साहब की अदालत ने सुन लिया, कोर्ट तो थी ना, वो तो गलत कॉमन यूजर्स होता है ना, गलत अदालत अब चलेगा या उसके पास इख्तियार ही नहीं था टू बिगिन विद, हमारे पास इख्तियार तो था, बस सिर्फ वो एक प्रैक्टिकल प्रोसीजरल मैटर दैट वुड बी रियली फॉर अस नॉट फॉर द लिटिगेंट, उसको क्या पढ़ना है?
I would say, my lord, and that I think to that extent,
I don't think that it will affect the decided cases. It has become past and closed.
I think that's the only fair conclusion that we can arrive at. And so far as
we're just going to take a short break. Let Khwaja Saab and others, and any other from the petitioner side. I see Mr. Bhandari. You are for the petitioner or the?
Your lordships had put various political.
No, who are you for?
I am for PTI.
Which side of the divide?
I'm supporting the petitioners, but I am also not saying that Article 191 is completely outs the powers of the Parliament.
I would really like to hear you. Anyone else from this side? Petitioner. तो अगर आप लोग articulate जरा कर लें, we'll take a short break.
My lord, I have actually filed my written submissions.
नहीं, why are you depriving us the pleasure of hearing you? Unless you want to deprive us, that's fine.
No, not at all, my lord. I'm here.
चौधरी साहब भी हैं. तो and of course we won't rush it. आप अपने जवाब भी दे दीजिएगा जो आप देना चाहते हैं. And we just come after. We just take a short. I think prayer time is also there. Short break. Huh?
And if I may be granted leave, I have to.
As long as you leave somebody here who knows all the things, and then if required, submit the. If you think if you want to, we can't force you to submit a reply. Or it may be in your interest to do so.
Attorney General, best wishes from all of us on the assignment they are on. It's in the national interest and it's very important for Pakistan. Our best wishes.
My lord,
I hope you are well prepared.
आपने 22 questions मुझसे पूछे हैं जी. You asked me.
अभी वापस आते हैं.
नहीं, 22 questions में you like me to ask you answer now, or you want me to give me some time to?
नहीं, हम जरा वापस आ जाते हैं. फिर आपको कुछ सुनते हैं. अगर कोई बहुत ही पेचीदा सवाल हुआ, फिर हम देखते हैं.
पेचीदा सवाल तो सारे ही हैं.
But देखिए, petitioner always comes prepared of all the questions कि सारे आ सकते हैं. तो वो देखें, other side can say that, but you can't. You are the petitioner.
May I say something?
जी.
देखिए
ख्वाजा साहब जरा बात समझने की कोशिश करें ना. The functioning of the Supreme Court has ground stand still. I don't want that to continue.
मुझे आप इजाजत दीजिए.
ठीक है.
मैं ये 22 सवाल जो है, मैं इनका जवाब लिख के आपको दे देता हूँ.
चलिए, आप हम वापस तो आते हैं. इनको तो सुनेंगे ना भंडारी साहब को.
शायद आप भंडारी साहब को तो मैं
ये ऐसी जबरदस्त बात करें आप.
भंडारी साहब को जो है मेरे पास आ चुका है जी. मुझे आप इजाजत दीजिए.
देते हैं, वापस आके देते हैं. देखते सुने तो कुछ थोड़ी बात
देखना तो ये है ना कि पार्टीज क्या कहती हैं, वो पार्लियामेंट की सुप्रीमेसी चाहती हैं या नहीं चाहती.
सुनकर मौखिक हमने नहीं सुना अभी तक. थैंक यू. यू कैन गो देन लीव समवन हियर कॉम्पिटेंट. हाँ, थैंक यू.
नाज़रीन, सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों पर समाअत जारी है. चीफ जस्टिस काजी फाइज ईसा की सरबराही में फुल कोर्ट बेंच इस केस की समाअत कर रहा है. अटॉर्नी जनरल मंसूर उस्मान ने दलाइल दिए हैं. इस मौके पर उन्होंने कहा कि इस बिल से इदारे में शफाफियत आएगी. हम यहाँ इंतजामी इख्तियारात की बात कर रहे हैं. ये कानून एक ओहदे के इख्तियारात से मुतल्लिक है. ये बिल अवामी खदशात को दूर करता है और ये अवामी मसाइल के हल के लिए है. इस मौके पर चीफ जस्टिस ऑफ पाकिस्तान काजी फाइज ईसा का यह कहना था कि अदलिया का काम मुकदमात के फैसले करना है. जस्टिस अतर मिनल्लाह की जानिब से कहा गया कि यह बिल साइलिन के मुफाद में है. जमाल मंदुखेल की जानिब से कहा गया कि आइन की कौन सी शिक है जो पार्लियामेंट को कानून साजी से रोकती है. अटॉर्नी जनरल मंसूर खान ने इस मौके पर दलाइल दिए जो हमने आपके साथ शेयर किए हैं. इस वक्त कार्रवाई में ब्रेक ली गई है. पीटीवी न्यूज से फिलहाल इतना ही. क्योंकि इतना मेस हो चुका है, इस मेस को संभालने के लिए टाइम रिक्वायर्ड है। मैं इब्राहिम साहब से इंट्रोडक्टरी कमेंट लूंगी। इब्राहिम
सवाल का जवाब भी कुरानी हकीम जो है वो बड़ी
फुल कोर्ट बन जाए तो बन जाए, कोई
फुल
फर्क नहीं
कोर्ट
पड़ता।
बन जाए, मैं ये कह रहा हूँ कि there will be
आप
there might be issues in time.
आप काइंडली जरा थोड़ी सी
नहीं, मैं there might be issues in time.
applications of your submission तो काइंडली देखिए।
मैं उसको ये इस तरह से आपको कर देता हूँ कि आप
देखिए,
ये बैलेंस आप रख
अटॉर्नी
लेंगे।
जनरल साहब, लेट्स बी we are all
Attorney
grown
General
ups, right?
Attorney General
Can I just the problem arose, I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say there has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done.